Hi, and welcome to The Mark You Leave, the podcast where we explore the entrepreneur's journey. And my name is Alex Mejias. With James River Law, and I'm joined today by my colleagues Bri and Tariq. And we're excited for you to join us again. In this episode, we're actually going to be talking about what is an estate plan. We thought it might be a good idea, again, to kind of begin with the end in mind and to just sort of set a foundation, a basic foundation of information for when we talk about what an estate plan is. A lot of people don't know exactly what that means. And so we're going to kind of try to address some of the basics of what an estate plan is and some of the sort of the common misconceptions about an estate plan, both a will and trust, all of those things. So we're just going to kind of go into it here, and hopefully this provides just some basic information for you all so that we all know what we're talking about. If you have any questions that come up, we do want to answer any questions. You can email us at podcast@jamesriverlaw.com. That's podcast@jamesriverlaw.com. If you have questions about anything that we're talking about here on the show, we would love to hear from you, and we will answer those questions as they come in on the podcast. So let's dive in. What is an estate plan? Well, a lot of times people just think of a will. They just think, well, it's you have a will. They come in and say, I need a will. And really what an estate plan is actually more than a will. It's a comprehensive set of documents that really talk about what will happen in any type of crisis situation, not just if someone passes away, but also if they can't manage their own affairs for any reasons, and a host of other situations. So it's really more than a will. It's a whole set of documents, and I'm going to kind of go through those documents now. So a will, I think most people know what that is. It's a very simple concept. It's a document that you write your wishes for what you want to have happen to your stuff when you pass away. But it also names an executor, who is the person that actually goes and executes the will, who actually who gathers everything and then distributes them to your heirs. And then if you have minor children, a will can also name a guardian for your children if you and your spouse or your partner are unable to care for them because you've passed away. So a will is a very simple document, but it does some really important things for you as a part of your estate plan.
So when I tell people that I work at a law firm, we handle estate planning. Their minds often go to will.
Right.
Then a lot of my friends aren't homeowners, not to put anybody on blast, but they often ask, what do I need a will for?
Right.
I don't own anything.
Right.
What would you say to that? Can you speak to that?
That's a good question. And there are some times where maybe you don't need a will. If you literally don't have anything, if you don't own any property, you don't have a car, you don't have anything, you don't have any children, you might be in a position where a will doesn't do all that much good, just being real. But we also, and this is something that I think we're going to talk about in the future, we're excited to kind of explore this idea of like estate planning on a budget, because there are some other things that you can do if you can't afford an estate plan, or if you don't have a will, or if you don't really need a will. There are things that you can do to kind of tidy up your affairs. And so we will be talking about that. But that is a good question. A will does help just to make sure that if you do this, no matter what you have, it goes to the right place. Right. When you don't have a will, there is a law on the books, a statute on the books that says that determines who gets your stuff. So if you don't have a will, you don't really have a say in who gets the things that you have. And here in Virginia, and every state has its own sort of statute and the order, probably all the same. Real. Who knows?
Probably similar.
Well, they probably are pretty similar, but typically it's your spouse, then your children, then your parents, then your siblings, and it goes on and on and on and on. And there's just sort of like an order. I will say for folks that are in situations where you might be separated from a spouse, but not divorced. That spouse, under the law, if you don't have a will, they will inherit everything simply because you're still married. So that's an important consideration, even if you're a younger person. Maybe you don't have a lot, but you don't want it to go to that ex who you're not so happy with right now. So it is important to have a will at a minimum, because that gives you choice. into like what happens with your stuff. Anything else on that?
I think one thing in state of Virginia, we have this thing called probate. We'll dig a little bit deeper into that in further episodes as well. But in Virginia, anything over $50,000 would have to go through probate if you're not planning strategically. And again, we'll get into more strategic planning on a budget, things like that. But I will say assets add up to $50,000 pretty quick. So I will say some people think, oh, I don't have a lot, but you might be there and you might be right over that threshold where you're causing a lot of extra work for your heirs. Right. So it's always good to have something in place. And like you said, keep that X out of those things that you don't want.
Yeah. Yeah, and if you're and one thing too, if you're an artist, if you're a musician, you might have intellectual property that has value. If you've made recordings, if you've written songs, if you've drawn paintings, if you're an athlete, you might have name, image, and likeness and rights, licensing rights that have value, and those things are part of your estate. So it is important to remember that like we own lots of different types of property. It's not just cars and houses. There's bank accounts. But it's also rights and different things, and intellectual property particularly is something that people don't often think about. But you might have written a bunch of songs, and those songs might actually have some value, particularly if they're bringing in revenue. But not every songwriter brings in revenue. But
Sure.
But hopefully, if you're listening to this and you are a songwriter, you're making money off of your music. And we can, like I said, that's a great. We will talk more about wills, and we'll certainly talk about probate a lot, probably. So the next couple of documents in every estate plan that we do here at James River Law are powers of attorney. And powers of attorney are documents that allow you to name an agent, a third party, someone else, to make decisions or to manage your affairs. So the first one is called a durable power of attorney, which is basically gives someone the ability to manage your financial affairs if you are ever incapacitated.
Now, let me ask you, because I get a lot of questions during signing meetings of what exactly is incapacity?
So incapacity is, well, first of all, it's something that you can sort of determine for yourself. So it's actually a term that's defined in your powers of attorney. Typically, though, the way that we define it is if you are judged by a doctor or multiple doctors to be unable to manage your own affairs. So you are in a coma, you are in some type of vegetative state, you are basically, or you might be deemed mentally incapable of handling your affairs. So anything where you are not able to manage your affairs, also if you're missing. And then we did have a client ask one time about, wait, am I kidnapped? Am I incapacitated? And we're like, well, yeah, if we're missing for any period of time, and you could define, well, if I'm missing for more than 30 days, you might need somebody to pay your bills, to pay your rent. Hopefully folks aren't going missing.
Right.
And that's not an issue. But what's much more likely is if you're in an accident, and you're unable, and you might be unconscious for any period of time, that's probably the most common form of incapacity. Anything else on that you wanted to add in terms of your understanding of it?
No, I think that kind of hit the nail on the head.
All right. Alrighty then.
So
All
if
right.
you don't have any powers of attorney in place, though,
Right.
what happens then?
So, so if you don't have any powers of attorney in place and your rent needs to get paid or your affair needs to get managed, whoever who would like to help you would have to enter into a process that's called conservatorship, which is a process of going to the court, proving that that person, you're incapacitated, and that that they're unable to manage their affairs, and getting a court order to be able to then be the agent of that person who's incapacitated. It's a long process. It's an expensive process. It's not one that you would want to put your loved ones through. So powers of attorney are actually a really important part of your estate plan. So we talked about a durable power of attorney or financial power of attorney, but then there's also a medical power of attorney or a healthcare power of attorney that allows people to make healthcare decisions on your behalf if you're not incapacitated. Now, if you're married, that might not be as much of a need, but certainly if you're not, or if you're single, you want to make sure you have somebody that you choose, again, to make those healthcare decisions. It's a very personal thing, and you may want to have someone who shares your values, who knows you, who is going to be making those very important healthcare decisions. So definitely a good idea to have powers of attorney in place. Along with the powers of attorney, we also do a HIPAA affidavit that's just basically giving your medical power of attorney the information that they need. You can sort of pre-approve people to receive that information. We've probably all filled out like HIPAA forms before.
Every time at the doctor.
Right, exactly. So, and that really just is like about your information. But if you're in an emergency, you might not be able to fill out one, or you might be at a different hospital, or you might be seeing a different doctor. And so you don't want to be in a situation where you've named someone to be your healthcare power of attorney and they don't even have access to the information that they need to make a healthcare decision. So that's a really important document as well. The other one that relates to your healthcare is a living will or advanced medical directive. And that's a document that allows you to make end-of-life decisions. So if you have been deemed to be in a permanently vegetative state and you are essentially brain dead, or you have some other condition where medical intervention will basically just prolong your life, but you won't have a meaningful life in any way, a living will allows you to decide to stop receiving life-prolonging care and to just be made comfortable and to die a natural death. Obviously not a super fun topic to talk about, but it is a situation that can happen. And so that's a very difficult and personal decision. And so a living will helps you take ownership of that decision and takes that out of the hands of like your medical or your healthcare power of attorney, so that they don't have to kind of make the very difficult decision whether or not they're going to sort of quote unquote pull the plug on you. So, so those are the basic documents in a will-based plan, estate plan. But you might have a trust-based plan, which is another type of estate plan that we do, where instead of a will as the sort of the cornerstone document, we have what's called a revocable living trust. In a revocable living trust plan, you actually do have a will as well, which I'll explain in just a second. But a revocable living trust is essentially an alter ego that you create for yourself. It is something. A trust is something that you create through an agreement, a private agreement called a trust agreement, and you essentially have three people that are involved in a trust. You have a grantor, who's the person who creates the trust. You have a trustee, who is a person who controls the assets and manages the assets that are in the trust. And then you have a beneficiary, who is the person who the trust assets must be used on behalf of for their benefit. And a trust, typically for a revocable living trust, if you set one up, you wear all three of those hats. You're the grantor, you're the trustee, you're the beneficiary, which is kind of why I call it like an alter ego, because it's really just you. You're doing all the things. You're taking money out of one pocket and you're putting it to the other. But the great thing about a trust is that you can name a successor trustee. And so essentially the assets get put into the trust through a process that's called funding, which again we'll talk about later. And now the trustee is actually the person who owns those assets. And because it's now a trustee, it's the role of the trustee in the trust. If something happens to you, you can name a successor trustee who steps into your shoes and is able to control all those assets without having to go to a court, without having to go to probate, without doing anything. They can just sort of just kind of hit the ground running. And so a trust is a really powerful estate planning tool because it allows you to avoid probate. It allows your estate planning process to be private. And it also gives you a ton of options for how you shape an estate plan to address a host of different issues, like if you're in a blended family and you want to make sure that your biological children receive a portion of their inheritance. If you have a spouse who you want to be taken care of during their lifetime, but then you want the remainder to go to your biological children, trust can help you with that. If you have property in multiple states or multiple jurisdictions, and you don't want to have to take the will and probate it in multiple locations, a trust can help with that. If you want to avoid probate altogether, just completely get your assets out of probate. That is what a trust is designed to do. So we'll talk a lot more about a trust, but the way that there are two kind of conceptual ways to think about it. One is like kind of like your alter ego. The other is just sort of like a container that you put stuff in. And so a trust, when you create it, is empty. So you do have to put stuff in it. And there are different ways that you do that. during your lifetime is the best way to do it, is to retitle assets in the name of the trust or take possession of assets in the name of your trust. But when we draft a trust-based plan, we also do what's called a pour-over will. So we basically change the nature of your will. So you still have a will, and it can still function to name an executor and a guardian. But that pour-over will basically take any assets that you own at the time of your passing and pour them into the trust. So that's why it's called a pour-over will. So it'll basically say anything that I own, put it into this trust. And if that trust is not there, then create that trust and follow the terms. And so that's how a will and a trust can work together within an estate plan. And so, Bri, in your experience, you've done a lot of work on the estate administration side, so you've seen trusts. What type of assets can go into a trust?
Yeah. So we see kind of all types of assets. Like you said, we can kind of do title updates. We can do beneficiary updates. So you could do real property. We can see bank accounts, any cash accounts, stocks, bonds, investments. I've even heard of mineral, oil, and gas rights. Like, really, it can be anything. Business interests. I know that's something we see a lot, is assigning business interests to the trust. And that's something I love about trust is no matter what situation happens, if your trust is named as either that title or the beneficiary, it's going to go there, and then whatever those terms are that are dictated in that trust document are going to go into place. So no matter what has happened, if somebody has predeceased you that was named in the document, it accounts for everything. So it really can handle all types of assets. I'd be interested in an asset that it wouldn't be able to handle, to be honest.
Yeah. And a lot of folks who have real estate or our clients will have like an LLC, like you said, that is owned by the trust. And so that provides liability protection as well, which is great. The trust can also hold NIL rights. It can hold copyrights. It can hold all different types of intellectual property as well, trademarks, really whatever. But typically we would do those within an LLC, and then that LLC be owned by the trust. So it's a really flexible tool. It's a really powerful tool in estate planning. It's something that we typically encourage our clients to do. It does require setup, and it costs a little bit more, but there are so many benefits from having a revocable living trust. And that's really only one type of trust. And we may go into more in detail in later episodes about the other types of trusts that are out there. But really, when we're talking about estate planning, the revocable living trust is sort of the cornerstone document, is really kind of the gold standard.
So trusts are, go ahead.
Oh, sorry. I feel like I hear a lot from clients too. Like they've gone through that probate process. Yeah. They had like a parent who didn't have a will, and they had to go through this. And that's like their main reason for going forward with the trust document, because they went through it and they don't want their heirs to experience it. Yeah. So I see that a lot.
Nice. So trusts sound pretty flexible, but can you kind of speak to, and this is for both of you, can you speak to whether a will may make more sense for someone in a certain situation versus a trust? I don't know if either one of you want to take that.
Yeah, I mean, I think that like if you are younger, you don't have children, you're not in a blended family, you don't own property, then a will can make a lot of sense. Also, if you're on a budget, a will is definitely a cheaper option. It's a more affordable solution. It's a little bit simpler. Certainly, if you are a little bit older, and you really want to kind of get all of your affairs, like my parents, they're in their 70s. They recently went through all this, and I said, we've got to do a trust. And so they moved from like a will-based plan to a trust-based plan. You can, if you have property in multiple states, really a good idea. If you have a blended family, it's a really good idea to have like a trust. But but we have some clients who will even sometimes say, like, probably doesn't make sense for you to have a trust right now. It's okay to just kind of go with a will. But I mean, one of the misconceptions I think is that it's only for older people, or if it's only for rich people. But really, it's just a tool that anyone can use.
I mean, I feel like that was a huge misconception that I had, was that trusts were only for like extremely wealthy individuals before I got into estate planning. And it's really opened my eyes of how important this is, no matter what you have, what stage of life you're in, having something in place.
Right. Just how much easier it can make for your family as well, too.
Exactly.
Yeah, and like I said, we will be talking about like estate planning on a budget, which I'm really excited about. Talking about like the creative ways to do things. There's some tricks that we'll share and some secrets. Tricks and secrets, but they're not really tricks. They're more just strategies, I guess. Tools and strategies. Yeah. It's like, how marketing can we get? Like, join us for the 5 tricks and secrets of estate planning.
Tune in next
I probably
week.
shouldn't say like as much as I'm doing, but So I think that. I do think though they're to be realistic. Not everybody's going to be able to afford or even have the time and energy, because it does require setup. So if just to be perfectly honest, like it's time. It can be time consuming. You have to retitle your bank accounts, and that's probably the most difficult part of it. Really, is like your investment accounts, those cash accounts. The rest of it is not too bad. We typically provide we do provide funding instructions and do help a little bit with that side. But if you have the time and capacity, but if you're a young parent and you're just like trying to survive, like I am like right now, you might say, maybe just a will.
Maybe in the fall when summer is
exactly,
over.
Yeah, exactly. No shame. There's no shame at all in having a will-based plan, because it is just light years better than having no plan. Particularly if you have minor kids, you want to make sure. And I have friends who have been putting this off for years, who have said, I need an estate plan done. Right. Let's get it done. And, to be honest, I put it off for years too.
So did I.
I think it's easy too. Nobody wants to talk about this.
Yeah. And, full disclosure, I had to force these two to do theirs. And recently.
We're talking about it for years, actually, for me. But it feels much better having one in place now.
Yeah. So Bri, I'll let you tell your story. No shame. I'm not trying to throw any shame at you. But you have been doing estate planning for a while.
I know. It was awkward one time when somebody asked me in a signing meeting if I had an estate, like what estate plan I had. And then I sat there for a second. I was like, ooh, I have nothing. I have nothing to say.
Honestly, though.
But I can't say that now.
Well, yes. Now you can say it. And now I proudly whip out my estate plan all the time because I keep it at the office. If you come in for a consultation, you might see my estate plan. I had the same thing happen to me. I was recommending a revocable living trust plan to a client, and she was like, well, is that what you have? And I said, no, I don't. I haven't done my estate plan yet.
She appreciated that.
And I got it done the next week. So it was good. It was good. I was so proud of myself. She ended up not getting her estate plan done, but I did. So that was good.
That's hilarious.
So anything else to add before we jump here?
I think it's a good stopping place.
Yeah, I think that's a good one. Dig a little deeper into different documents, best practices, a little deeper in different episodes.
Yeah. If you want to learn more about our services or about our firm, please check out our website, jamesriverlaw.com. We do offer webinars on a regular basis. We offer webinars that talk about estate planning for business owners, entrepreneurs, estate planning for creatives and artists. We talk about wills versus trusts, do like a little bit of a deep dive there. And we also just do like an estate planning 101. So please do check out jamesriverlaw.com, and you can find a link there to our webinars that we hold on a regular basis. So please do check that out. And then if you'd like to talk about your estate plan, please reach out to us. You'll probably be talking to Tariq or Bri or me, and we would love to help you with that. So with that, we're going to sign off. Thanks again for tuning in, and we will look forward to seeing you next time.